Hi, everybody. This is attorney Arkady Frekhtman. I'm a New York City personal injury trial attorney. And today we are going to do part 3 of our analysis of a trial, an actual trial. This one was recorded by the Courtroom View Network, and it was a car crash case with a traumatic brain injury as well as multiple spinal fusions, a serious case. And today we're going to look at the closing arguments for both sides, for the plaintiff as well as the defendant, and we're going to try to analyze some of the interesting moments. Okay, let's get into it.
We have a case of Miyamoto versus Services Director will reflect counsel of president, all jurors, and all our president. Mr. Rowley, you may finish.
Thank you, Your Honor. We left off here. She didn't want this. She didn't want any of this. She wanted just to be a mom and raise a family. We heard her parents split up when she was young. She wanted to have her own family. And that's what she was building. And it was going just fine until that big truck changed it. We saw that shattered window. That's who she was. And she was shattered. She has not been the same ever since the day of this wreck. And she will never be the same. It's been pieced together. The way her life has gone and the way it's going to go, it's dark. We've seen the changes in her brain. Her brain is changing as time passes on. And that's what happens with a brain injury sometimes. We hope not, but it is what's happening here. She's unlucky. It's their fault. Her brain is, you see that there's atrophy, there's change in the ventricles, and we can take that if we, and we've learned together about neuroimaging and about neurology and about brain injury and what happens. And we can take that study from 2017, and now we see the progression, and it matches the progression of her symptoms. And what they want to do is say, well, look at her, she's inconsistent, she's this. They've acknowledged, they're experts, that she has a psychiatric injury. Brain injury can cause people to have psychiatric damage. It can turn them into really someone who's crazy, someone who is mentally ill, someone who is not right. We could go right down the street, not 8 blocks, 9 blocks to Skid Row, and find a whole bunch of people with PTSD, traumatic brain injuries, and chronic pain. Because after those things, the culmination, you take them, chronic pain, PTSD, traumatic brain injury, psychiatric injury, you put that onto somebody, and it's going to gnaw at them. It's going to wear them down. It's going to break them down until people just don't want to be around them anymore. And without the resources, without the help, without the compassion, without the understanding, your common sense, your experience, we know where they end up. It was this day we heard from someone, again, completely independent, who came in here, who documented she's still having pain in her face. And she took that picture because to her it's different. And we can each look at our own face in the mirror from one day to the next and know if there's a difference. Her glasses broke. Explain that. Whether she hit her head or not, it doesn't matter. Her Dr. Jabor told them, you just heard that testimony, is the last piece of evidence in this trial. And Mr. Fox said, well, you're not saying it's brain, you're just saying it's consistent with brain injury. And then he read those little, cherry-picked portions of the deposition. Then I put it into context and read the rest. He's been telling them all along, and they've known that this is consistent with a coup-contrecoup. That's the mechanism of injury. And there it is in the testimony that they had, that they didn't read, that I did read.
So you can see like a lot of this is about proving that it's a real brain injury, that it's some of the symptoms of brain injury include the progression, and they talked about this earlier in the trial in opening statements and some of the witnesses, and that you can become almost like mentally ill, right? Because it's a brain, and it doesn't like injure right away. It could be a slow bleed that could take days or even weeks, and then or even sometimes it atrophies and that. But it starts the progression. The crash starts it. So yeah, this was a real deep dive into brain injury. Let me see if there's other parts of it that I could also comment on. This is actually the second part of the plaintiff's closing, because I guess they started on one day and then they had to take a break, and then they finished the next day. And this was the original closing. Then the defendants gave their argument, and then after that, there was the rebuttal closing for the plaintiff.
So Layla, we go back in time to that day, and imagine for a moment that someone stopped her as she's leaving the house, came up and knocked on her car window after she's put her little boy into his car seat. They say, "We've got something for you." It's a lot of money. Upwards, close to $100 million. She goes, "Well, what? I didn't enter into the sweepstakes. What are you talking about? I didn't do anything to deserve that." "Oh, but you will. You see, we're a company, national corporation. We're going to give you this. But there's a catch. Today, at some point, you're not going to know when. Your life is going to change. Who you are as a mother, Layla, who you are as a mother, it's all going to change. Your body, that smile that you walk around with, that bright shining light that you are, it's going to dim more and more. You're going to have your neck injured, your shoulder, your back, your brain, your life. Chronic pain is what you'll have. As long as you live, you're going to have end-of-life injuries. But in exchange, you're going to get this money." She would say, "No, I just want to be a mom. I'm happy. I'm in the house I was born in. I'm happy. I have all that I need. I like to go camping. I love to play with my kids. I'm an active mom. I like to hike. I like to walk. I like to ride bikes." "Oh, no. You're not going to be able to do those things anymore. You're not even going to be a shadow of yourself." "Well, I don't want that." "Well, you have no choice. And this will be reasonable compensation for the rest of your life. This is what we, the company, will give you." She'd cry and she'd say, "Go away, please. I don't want that." So the jury verdict that we believe is righteous, that I hope you believe is righteous, is justified.
So that's basically like the man with a briefcase argument, saying like if someone comes and gives you whatever amount, $100 million, but you have to give up what you gave up, right? All your fusions, brain injury, would you do it? And of course, no, you wouldn't, but this happened to you anyway. So now you have to compensate the plaintiff. And then they turn and they argue about the defense experts.
This is who they, and remember those questions at the beginning of the trial where they're saying, well, you're a doctor at, Dr. Siegel's at UCLA, and LA. I said, well, she's in Long Beach. Why would your lawyers have you see a doctor at UCLA or in LA? And then they have her seeing a doctor down in San Diego and in Santa Barbara. Hypocrisy? It's beyond that. But of all the different board-certified chronic pain physicians in this community, UCLA at Cedars, USC everywhere, they get this guy who has to go to Yuma to stay busy, who doesn't even put in spinal cord stimulators or do these procedures. Well, that's the quality of experts, and it could have got anybody.
Yeah, and that's a common argument too, because a lot of the times the defense will use the IME doctors, the defense medical examiners. They call them IME, independent medical. They're not really independent. But the point is, a lot of these doctors become courtroom doctors. They're like professional testifiers, and they don't actually do the spinal stimulator. They don't actually do the surgery anymore because they spend all their time just writing these reports and seeing people. It's almost like a factory. So then they bring that up to say that, look, we have real independent treating doctors, and they could get any expert they want, right? Because they're this big corporation, but this is who they get, people from other states who just don't know anything, don't even do these procedures.
But this is who they could find to do the job that they needed to have done, to rake Layla over the coals. We learned about the forces. We know what did this. It's not a blood vessel. That's an injury to the insula, backed up by research. It all fits together.
So they show the scans again. They have this 3D imaging of the actual scans, but coming into her head and explaining where the injury is. They go through some of the doctors, because remember, you're summarizing the evidence. This is the closing argument. So they go through, and then they talk about the amount of years as well as how much per year, and then for all the different compensable categories. Maybe let's watch that.
And wouldn't it be reasonable? But we got to stack it up, each item of harm. Physical pain for 1 year, 100,000 wouldn't be reasonable. And when we stack all these together, this is where the $1 million to the $1.5 million per year is reasonable for non-economic damages, because we stack them all up. The physical impairment, she can't, sorry, you're not going to be able to power walk anymore or ride a bike, and you're not going to walk the same. But just for that, and we're going to inflict pain upon you. Layla Miyamoto, would 500,000 a year be fair to inflict those things? No. That's where the 1 to the 1.5 million a year is reasonable and righteous. It's righteous. And it's not to be reduced to saying, oh, well, if we gave her 25 million, that's going to be, she can put that into an investment, that'll earn this much interest. That's reducing it to present value. And the law says not to do that. So it's just, what is it per year? Year by year by year, knowing that it's gotten worse and it's going to get worse. That's where that 1 to 1.5 is reasonable and righteous. That any one of these things could justify that. In a non-economic damages case, we might have just one of these things or two of them. But here we have all of them. And that's why this number is right. So when we break it down and we look at it year by year, it's not that big. But when we look at it as a whole life, yeah, it is. Because what's happened is big. What's happened is catastrophic, massive to her life. Do not reduce the non-economic damages to present cash value. And with respect to economic damages, the burden of proof shifts to them. They didn't meet it. In fact, they're economists. We established through cross-examination that it's going to cost more because of the rising cost of healthcare. Humiliation, that's a separate item of non-economic harm. Humiliation for 1 year. For 48 and a half years, because it is humiliating to be her and to live this way and to go through all this. It's humiliating. To get lost in the store, to not be able to just be the human that she was.
So this was like the explanation, right? Because it's 1 to 1.5 million per year for all those things: the grief, the humiliation, the loss of enjoyment of life, the pain, the suffering, and then of course they also have other damages that are economic, like Would they have a life care plan and the costs, medical costs and things like that? So let me skip ahead and see. We can jump into some of what the defense had to say.
The reason I want to show you it is because that's the bedrock. That's the bedrock for our civil justice system. It doesn't talk about you have power. It doesn't talk about your job. It doesn't say protect people. It doesn't say defend people. That's not your jobs. So I want to go to the oath you took that day and put that up. This was the oath you agreed to follow. Do you and each of you solemnly swear that you will well and truly try the cause now before this court, and a true verdict therein render, according only to the evidence and the instructions of the court? That's it. If you want to call it a job, I call it a duty, but there it is. To render a verdict, in this case, based on two things: evidence and instructions of the court.
So he's basically saying that don't listen to the plaintiff. He's saying that you have this duty to help and, civil justice. It's not that. It's just, only the evidence and the instructions of the court. Keep it more like clinical. So he's trying to take away like sympathy and things like that. Let me jump ahead, see what else he has to say.
All those medical records, all the treatment, all the diagnoses, all these experts looking at her. Nobody came up with that. They came up with that because this theory of hitting the steering wheel can't be sold to a jury. So now they're going to go with a coup-contrecoup. I'm going to talk about that for a second. But that came up for the first time in the middle of this case, for the first time. It came up from Dr. Siegel. Remember Dr. Siegel was sitting back there, and then it was time to testify. He put his white lab coat on and walked up as if he had just come out of the operating room. First time anyone in this entire case, over 8.5 years, mentioned it was on January 22nd, 2025 at 11:30 a.m. in this courthouse. That was Dr. Siegel. By the way, I've asked several witnesses, is there anything in the records about coup-contrecoup? It wasn't even in Dr. Siegel's own report. He didn't even say it in his deposition. It just came up in this case on January 22nd at 11:30 in the morning for the very first time.
So he's basically saying that because they didn't have an argument about her hitting the head, that they came up with this new argument of coup-contrecoup, of the head moving within the skull. And they came up with that right during trial, and it's not in any prior deposition, not in any prior report. So he's kind of calling it baloney. Jump ahead a little more.
Plaintiff's evolving theory of the head hits the steering wheel. We saw this picture. It's trial exhibit 1047 that Ms. Miyamoto's, I think she took it or her husband took it the day of the accident. Okay? It's in evidence. You're going to have a copy. Please look at it closely. Look at it. Try to find a scratch, a bump, a bruise, a hit. It ain't there. What you're going to see is on the right bridge of her nose, there's a pad, like the pad that you can get from an eyeglass. There's nothing there. And I think in their animations, they have her hitting over the right side, over the right eye. So look over her right eye, which is on the left as you're looking at this picture, and look for anything that would show even a scratch from hitting the steering wheel with such force and impact that she would damage her brain. Okay? Normal is greater than 26. How's the score of 29 rank in the world of claimed brain injury? Well, that's a normal score.
So again, they're trying to say that everything is normal, the photos don't have anything, the score of 29 is normal on some kind of test, everything is normal.
Million. You get to decide credibility here. Why? Where is this coming from? Just wants to keep jacking up the numbers. The 2025 plan he prepares for this trial, he comes up with a whole new number of 18,738,000.
So they're saying the life care plan is also, they're coming up with new numbers, it's not proper, it's too high.
Every dollar you want to award, she's got to prove it on the non-economic damages. A few more instructions, I'm going to tell you what my number is. Mr. Rowley, trying to get you angry, used the word corporation about 7 times. Corporations over here, corporate lawyers, corporate playbook. By the way, I'm a normal human being. I'm not a corporation. I don't have a playbook. I'm doing my best. We're doing our best to defend our client, just like they're doing their best to advocate for their client. That's what we're doing. I don't have a playbook. Every case is different.
Okay, so that's pretty much the defense closing. And then we can go to the plaintiff's final rebuttal closing. And let's see what they talk about there.
Mr. Bruno, you may give the closing portion of the plaintiff's closing argument.
Thank you, Your Honor. So, yesterday, you heard so much lawyering. You know, this witness said this, and this witness said that, and this expert, and you heard this, and you heard that. That was a lot of the afternoon. And I just wondered if we could actually take a moment, a real moment, and just remember that there was a woman in that car. There was a woman in that car on that day. And she had her own hopes and her own dreams and her own aspirations. And none of it involved any of these doctors. It didn't involve these lawyers, myself included. She never had that aspiration for herself. There was a woman in that car on that day that came out of this different. And that sometimes gets lost with all of the PowerPoints and the back and forth of a cross-examination and then re-cross-examination and all of this. But there was a woman in that car. And I thought to myself, because I didn't hear this from the defense, you know, they broke her neck. They broke her neck. They broke her shoulder. These are things they don't dispute. They broke her back. The woman in that car, they admit that they broke her neck, and they broke her back, and they broke her shoulder, and they broke her brain. And then there was so much about the science, and we brought scientists in here to tell you about the brain, and we learned things in the closing argument. And all of this was to say that we're not responsible for this. Now, I have had the privilege of living a very rich and interesting life, and I don't mean financially. I mean, things happen to me, and I see things and I have experiences, and I'm really blessed to have had these. And I can tell you a story, and I'll tell stories. I'm not going to try to back and forth you or ping pong you with experts. But let me tell you a story. It happened some time ago in the summertime. We were at the farmer's market, myself and my youngest son. He was 7 at the time, Ford. And I'm walking through the farmer's market, and this woman stops me. And she's holding something in her hand, and she says, "He broke it, this is going to be $50. And it was a crystal. And I looked at my son because I was upset that he hadn't told me. I was at another part of the farmer's market. I think I was getting fruit or something like that. And this woman comes up and says he broke it. And if you have children, you know this look where and he's a good boy. He begins to implode from inside. You can see the tears begin to well, and he's just mortified. And I know he broke it. And I know I owe this lady $50. But I have a choice, don't I, in that moment? Or at least a version of me has a choice. And the choice is, I could say, Did anybody see him break it? Is he on video breaking it? How do you know he broke it? Maybe he didn't. Maybe it was already. Let me see that. Let me see this crystal. This crystal looks like it was broken before. I see imperfections in this crystal. Look, I'll tell you what. I'll give you $5 for the crystal.
So this is good. What he's doing is he's showing back to that responsibility theme that we talked about in opening, right? And he's saying like that's real responsibility versus fake responsibility, and real repentance versus fake repentance. And what they're essentially doing is they're saying, oh, how do we know this was us? How do you know you have this injury? How do we know it's real? So he's making an example with breaking a crystal. And I think it's a powerful argument.
I think it had problems before. I'm not a crystal guy. I don't really care about crystals. I don't know about crystals. Oh, okay. All right. Well, here's what we're going to do. I'm going to get a crystal inspector, a price crystal inspector, and he's going to get a report. And 8.5 years from now, we're going to take a look at that report. And then I'm going to offer you perhaps some money, or maybe I won't. Or maybe I'll just try to confuse the issues, and maybe then I'll throw a bunch of different figures on the board. None of them are the $50 that the crystal was actually worth. And of course, in that moment, I can tell you folks, I didn't do any of that at the farmer's market. And it's not just because that would be wrong, but it's because of the example that you set. When you do something like that, when you make those types of arguments and take those types of positions in front of a child or in front of someone, anybody, an adult that looks up to you, they have that really insecure and terrible feeling that dad's not playing it straight. Dad's not giving the straight, dad's not behaving like I expect him to. And that is probably the most powerful way to crush a spirit. We have seen versions of that. The latest version, the first thing that they did was they got up and they accused Mr. Rowley of trying to rile you up, pull on your heartstrings. There was a lot of different phrases used for it. But I told you in the very beginning that you need to evaluate the side that gives it to you straight. And I didn't see that from Mr. Rowley, and I didn't see that from anybody, any of us who actually represented Ms. Miyamoto. Here's what I saw, and see if you saw the same thing. I saw a lawyer who has an acute and broad understanding, an expert level understanding of traumatic brain injury. And I saw him try to get you so much information. I saw Mr. Rowley trying to get you every image that you have and then some. I saw Mr. Rowley getting you putting up medical record after medical record after medical record, literally doing everything he could to deliver the information. I saw him cross-examine these brain experts, which each one of them, every single one of them, while they initially took this position, I'm sure she's fine, I'm sure it's no big deal. After the cross-examination that Mr. Rowley did, which was about the standards and the medical criteria and the medical science and the authoritative papers and the MRIs, every single one of them, you can look, came back and had to admit, actually she is brain injured. Actually this hasn't gone away. Actually you're correct. And you can look at Mr. Rowley and say, I think he talked too much, or geez, he never would stop cross-examining these people because they weren't telling the truth. And the cross-examination is what it took. But what you can't do is you can't, over these 4 to 5 weeks, how much ever long it's been, you cannot say that this side of the table did not endeavor to get you all of the information about the brain.
Yeah, so that's a good point. He says, like, look, we gave you everything. We gave you more than even maybe that is necessary, but we wanted to give you all the information. And he talks about how they're like real experts. And I think that kind of came through in the trial, that the plaintiff side maybe knew a little bit more about the brain injury than the defendants, who didn't really understand brain injuries as much.
That in mini opening statement told you this was worth tens of millions of dollars, that in his opening statement said the evidence is going to show and the verdict will be justified of over $70 million. It is the same Mr. Rowley. He didn't slow roll anything. This has been known to this jury, and this has been known to System Services of America long, long before today. So what do? They broke this woman's neck, they broke her back, they broke her shoulder.
So he's saying basically that, I think the defense lawyer in his closing was saying like, oh, you didn't really come out and say how much this is worth. You tried to like slow roll it or whatever. So he's saying, no, we told you from the opening it's worth between, I think, 48.5 to 72 million. And so now he's gonna talk to them about what they did and how they're really, we'll let him talk about it, and then maybe we can analyze it.
They required a spinal stimulator, and they broke her brain. I looked up the definition of gaslighting because I had a very uneasy feeling about what I'm hearing and how to synthesize it. You know, maybe it was a tic. Maybe she had this genetic condition that she was born with. Maybe this, maybe that. And I have trouble processing how you might process just flooding the zone with BS, right? Just flood the zone, and maybe it gets confusion. And maybe back in the jury room, one juror says, well, look, we don't know for sure it wasn't a tic. And one juror says, well, she had this genetic condition. And another says, well, I think she had PTSD, but I don't know about chronic pain. I don't know enough about chronic pain. If you get that dynamic going in the jury, you start splitting the jury, and then it becomes really difficult to agree on what's been before your eyes. That there was a woman in that car, that the woman in that car was gravely and seriously injured, and that because of that, they don't get to discount her and discount her life throughout this trial as they've done.
So that's a really smart tactic too, because what he's saying is he's bringing up the defense points, and he's kind of like, don't let them trick you. Don't say, oh, it's really a tic, or how did they didn't really prove this. He's kind of mimicking how the jury dynamics could go, how the actual deliberations might go, with one juror saying, I have a doubt about this, and I have a doubt about that. And then, but what's the evidence, right? It's more likely true than not true. What's the greater weight of the evidence? It's for the plaintiff. So that's a good argument, because it kind of gets rid of those doubts, right? As opposed to allowing the defendant to keep throwing mud up against the wall and say, oh, that little piece stuck, you know, and seeing what sticks. So I think that's a good argument.
User denies facts, feelings, or the victim's perception of an event. We saw that repeatedly. The abuser questions the victim's memory or judgment. She says she doesn't remember it, they use it as a sword against her. She reports just the basics of what happens, now she has memory, they use it as a sword against her. The abuser makes the victim feel unimportant or oversensitive. Oh, all these doctors, what did he call it? What did Mr. Fox call it yesterday? Catastrophizing? He accused her. He accused someone who they broke her neck, and they broke her back, and they broke her shoulder, and they don't even dispute that. He accused her of catastrophizing. That sounds like a catastrophe to me. If my mom was in that car and that happened to her, it would be a catastrophe in the Bruno family, or any family, and it was a catastrophe in the Miyamoto family that had a ripple effect like a pebble in a duck pond. And the abuser switches between charm and rage. We heard yesterday Mr. Fox say repeatedly, I'm not criticizing. To me, that was like when someone says, with all due respect, you know that you're about to be disrespected, right? I'm not criticizing. He kept saying it over and over, and then he just criticized Ms. Miyamoto, the lawyers, Mr. Rowley. I think I was somewhat spared from it, so that was fun.
Let me jump ahead to the rest of it. So basically he's going through some of the evidence, going through some of the arguments.
The person who hit the other person, that's the person who would volunteer that information if it was relevant, and more importantly, if it happened. The person that slammed on the brakes, that's the person that would say, or excuse me, the person that claims someone stopped short and slammed on the brakes, that's the person that would say, this is what happened. In fact, it's such gaslighting that if the scenario that Mr. Elmazon said happened, that's all you would say. Look, I was driving at a reasonable speed. This woman just swooped in front of me, slammed on the brakes, no turn signal. I couldn't do anything. I hit her. That's the explanation if it happened like he said. We know it didn't. They want to talk about science. It is a matter of physical science as to whose skid marks were on the ground. Both vehicles allegedly came to a screeching and sudden stop, and there's only one set of skid marks. It is science that only one of those vehicles was carrying a lighter weight and had a professional driver behind it that knew his stopping power was not enough.
So he goes through liability again to show that they're not at fault. And let me see, towards the end, he talks about the burden of proof here.
True than not true. And I certainly think we have. And when I say each of the damages, just take a look at those. The law is very clear. The law says that you can't discount anxiety or disfigurement or humiliation or physical pain. They're all equally important in the eyes of the law. And the law equally mandates that you break it up into past and future, which is why the verdict form that the judge is going to send you does just that, right? So the verdict form matches exactly what the law wants you to do. Less money in economics today, because if invested reasonably, she'll have so much more money in the future. Which just, with one graph that took me 15 minutes to look up off the internet using public sourced information, we just know that's not correct.
This is not evidence. Counsel's, that should not be evidence.
So basically he's talking about the life care plan, the economic damages.
And that's the legal standard. You take a victim as you find them, and justice returns them as best as we can to how they were if the negligent act didn't happen. You want to know about justifying the numbers? That is the justification of the numbers, and that is absolutely the law. The non-economic damages, as you saw from the things that you have to consider. Mr. Rowley gave what's a per diem. How much per year over the life of her, over her life? Now, we're not talking about the money that goes to the doctors. We're talking about the money that goes to her. To undo this cosmic tear in the universe that was created by them when they injured her and set her on this course. And of course, it's not how much they want to pay. It's how much is the value for the individual plaintiff, for Ms. Miyamoto, according to this evidence. That's the standard. And I still suggest to you that the best way of doing that is to see what she would have taken in trade for this life. Would she have taken $12 million for all these 8 years, a time before my son was even born? Would she accept that, or would she rather have her health? Would she take 60 for the future? The richest people in the world, Steve Jobs, on his deathbed, as far as I know, did not ask for his bank statement as his dying vision. He asked for just a few more days of health. But he didn't get it.
It doesn't matter what your socioeconomic level is. And you shouldn't be biased that Ms. Miyamoto's socioeconomic level is not at Steve Jobs or anyone else. It's not relevant. It's only meant to be foisted on you so that you think, maybe she isn't worth these, what was it, a different case, different worlds of money. No, I would submit to you that that is reasonable and based on the evidence for what she has been through and what she will go through. Every percentage that you assign to Ms. Miyamoto represents dollars off of your verdict. And not all jurors understand that going in, but it's true. I'm not going to lavish praise on you. I'm just going to say thank you for listening. Thank you for coming back in the morning. The case is going to be in your hands in just moments. You'll pick a four-person. You'll be guided by your common sense, by your moral compass, by your sense of community, and your sense of justice. Like I believe I have at least endeavored to do my best to mirror and provide to you during this trial. So thank you so much, and God bless.
So that was the end of the closing, and then at that point, the judge reads the jury instructions as to what the law is, and then the jury deliberates and then make a decision. And here, the verdict, I believe, was 21 million. Okay, past economic damages were 825,000. Future economic damages were 6.5 million. Past non-economic were 4 million. Future non-economic, which is pain and suffering and all those categories like grief and humiliation, all, loss of enjoyment of life, everything that's non-economic. Really, it's more of the pain and suffering. That's 10 million, right? So 825 plus 6.5, so over 7 million in economic, and then 14 million in non-economic. Total was 21,325,000, but with the interest going back, it was actually closer to 32 million or 31 or 32 million. So I hope this was helpful. Let us know what questions you have. This was an analysis of a trial. We couldn't do the whole trial. It's like a 5-week trial, but we tried to pick some snippets so you get a sense of the opening statements, the closing arguments, witnesses like lay witnesses, doctors, to see how a trial goes and how the result goes. And this was a case actually, like we talked about, that's right up there, right? Because it's about fusion surgeries, back injuries, pain injections that a lot of people have, herniated discs, also traumatic brain injury, concussion, but it was the mild type. So very interesting, and let us know what you think. Please like and subscribe to our channel, and all the best, everyone. Have a great night.